Good morning, everyone, and welcome to Estate Administration Week. This is the final session of 9 very successful sessions that we've had this past week. My name is Noel Xavier, and I am the Director of Development with Edmonton Community Foundation. It's my pleasure to be your host for this session, and we are so happy that you can join us this morning. Many of you are already familiar with our annual Wills Week, held every October. This week, we're launching a new series of presentations that are similar to those that you've attended for Wills Week, but with a specific focus on the ins and outs of effectively administering an estate. At the Edmonton Community Foundation, our role is to help create legacy for the community. And we are a trusted resource for Edmontonians to provide ongoing endowment support for the charitable organizations and issues that they care about. As a result, we have many conversations with people in our community about their wills and estate plans. And we've learned how important it is for people to get valuable information from wills and estates professionals. Just before I introduce our presenter for today's session, I would like to let you know that at the end of the session, you will be given the opportunity to fill out a survey. As this is the first time that we are hosting Estate Administration Week, your feedback is valuable to us and it will help us to plan for next year. A reminder that today's session is being recorded, and so it will be available by the end of the month on our website at www.ecfoundation.org. That website again is www.ecfoundation.org. You will be able to check back and watch today's session, as well as all of the other sessions, and we encourage you to share those sessions with family and friends. For questions and answers today, I will ask that you put your questions into the Q&A function. Depending on the Zoom features that you have, that function should be at the bottom of your screen. We will not be monitoring the chat, so please make sure that you put all of your questions in the Q&A. And at the end of the presentation, there's time for us to go through the questions. And so now I'd like to introduce our speaker. Benjamin Taylor graduated from the University of Alberta, Faculty of Law, in June 2012, and was admitted to the Alberta Bar in 2013. He joined Barr Picard as an articling student in June 2012, and is now currently a partner with Barr LLP. And actually, just before we started this session, he let me know that that partnership was very new, so congratulations, Ben. Ben's focus is on property-related areas of law, including corporate and commercial law, wills and estates law, and real estate. In addition, Ben is a former chair of the Northern Alberta Real Property section of the Canadian Bar Association and is a father of 2 young boys. Please join me in welcoming Ben Taylor.
Normally when we do that handoff, Noel, people clap and we know to start when they stop clapping. I'm still getting used to this new venue. It's been a strange year for all of us.
Exactly.
So anyways, before I go on talking about this topic, I do want to take a moment to thank the Edmonton Community Foundation for putting these events on. Wills Week in the fall has been going on since before I was born, I believe. This new program of doing estate administration stuff in the spring, I think is a really valuable service. And I'm glad so many people are tuning in, and ECF does a good job of promoting these events and getting people to come. So I really want to thank them for doing that legwork and for taking the initiative to do this. As far as me, as mentioned, I'm a wills and estates lawyer, and I've been doing this for, I think, 5 years with ECF. I do practice in other areas, but this is the main thrust of my practice. And I have been asked today to talk about an arguably playful topic about what not to do as an executor and how not to get sued. Now, this is meant to be a playful title. We're not trying to suggest that lawsuits are a common and unavoidable aspect of estate administration. It does happen, but there are a lot of mechanisms in place, a lot of processes in standard estate administration that's designed to avoid that. And so we're going to talk about some of the common pitfalls that people take. And I will say that contrary to what a lot of people believe, most of the time, it's not malfeasance. It's not bad behavior that leads to litigation and disputes in estate administration. It is almost universally honest people making honest mistakes. So if you're saying to yourself, well, I'm honest, so I don't have to worry about this. Well, actually you do. The reason we have all these difficult processes that are hard to follow is because honest people, even if they don't make mistakes, but just don't follow the processes right, lead to disputes. Since we're trying to help cut down on that. So because we are doing this on Zoom and it's a tough format to follow, a lot of detail, we're keeping this pretty short today. So the only 6 things I'm going to cover are these ones, and a recommendation about not skipping steps, failing to protect assets, making distributions of property before you're allowed to, making distributions of property before you pay the tax man, and neglecting to maintain good accounting records, and that's a big one. And then finally, the biggest one of all, in my opinion, is good communication with people who are involved in the estate. Because even when you do nothing wrong, that doesn't stop people from believing you have. And most of the time when I navigate and manage disputes, it isn't actually because something's been done wrong. It's because people believe there may have been and just don't know. So we'll go through all these in sequence, and when we're done, we'll have some time for Q&A. Apparently, we've been having lots of questions at these sessions this week, and there should be lots of time to go through them. And that's probably where we'll get the most interesting back and forth, where people will be able to learn something, because I can only envision so many topics on my own. You all collectively, since there are more than 100 of you, probably have lots of great ideas you want to talk about. All right, so first off, not skipping steps. If you've ever administered an estate or seen a checklist for what an estate administration involves, an awful lot of it looks like it's either not applicable or you can't be serious. Do I really have to do that? And the answer often is no, you don't need to do all that. However, you probably should check with the lawyer first to see if you can skip steps, because they are that way for a reason. And they're designed to avoid problems by doing things by the book. So a list of 7 steps is my sort of bird's eye view of estate administration in its most elementary form. So the very beginning is after a person dies, there's this notification and information gathering stage of administration. And what that usually entails is going to all of the banks and the brokerages and the employer and contacting CPP and OAS or a union or civil service organization just to notify them that the person's died and to obtain information about money that's payable to the estate. And people usually do this without being prompted. It's very intuitive, but it's easy to miss 1 or 2 of these things. A very common one that a lot of people don't realize, and it takes the funeral home to prompt them about this existence, is that anyone who has worked for about 3 years and paid CPP dues is entitled to a death benefit of $2,500. And so sometimes I'll get people who are well into the estate process and haven't contacted a lawyer yet. And I'll ask them, have you applied for that? They don't even know it exists. So it's important to reach out to all of these organizations and find out if there are benefits payable to the estate, because if you're far into it, it's a bit of a nuisance to have to go back and backfill that information that you missed in the first blush. Once you've gathered the information and notified all of these third parties that are holding assets of the estate, that's when the lawyers usually come in and we apply for what's called a grant of probate or a grant of administration. And what that is it's a series of court forms that we file with the court. Usually it's a package that will include the will, it will include some information about the deceased's family and relatives and beneficiaries, and it will include an inventory of the assets that are in the estate. And the court is really just there to create a forum for the family to speak up if anything looks missing. And again, that can happen through nobody's fault. You might have contacted the bank and got all this information, but you may not have realized that that your deceased grandmother or whoever co-owned a quarter section up near Cold Lake, and you just didn't know that that was there. And it will take a relative to speak up and say, hold on, what about this asset? And that's what that process is designed to do, is to give people notice of what's going on and give them an opportunity to speak up and point out things that are missing. And that's why that process is good, even though it takes a bit of time and can be a bit of a nuisance. It's a great way to create an open forum for feedback. So once you've obtained that grant, and that usually takes a couple of months once it's filed with the court, you can start to liquidate assets of the estate. And this means going to the brokerage that holds the TFSA and the RIF and telling them, okay, liquidate those investments, give me a check so I can deposit it into the estate checking account. That involves selling the condo that's been sitting vacant for several months. That will involve collecting a life insurance policy and making sure it's deposited. That's why it's important, again, to do that information gathering stage at the beginning, because you can't liquidate assets you don't know exist. And sometimes there's complications around those assets that have to get sorted out. Maybe the life insurance, one I have a file right now where a person signed to change their life insurance policy in the weeks before her death, and she had dementia. And so there's an open question about whether or not those changes should be upheld or if they should be reverted to the previous beneficiaries. And if we had started that process 6 months in, it would cause a long delay. But thankfully, we started it at the beginning and we're working through it, and we haven't got a grant yet. It hasn't even been filed, in fact. So it's good to do this stuff in the proper order. Once you've liquidated everything, you start paying out the debts of the estate. And this can range from, the property taxes and insurance on the house, covering utility bills, paying down some credit cards, paying lawyers and accountants and other professionals who are working on the estate, and making specific gifts in the will. So the will leaves, $5,000 to this niece and $10,000 to this nephew. That's when you can start making those lump sum payments. And again, important to do it in order. If you start making payments before you've identified all the debts and assets, you might accidentally make payments that you ought not to have made because there isn't enough money to pay everybody. So it's important to do that all in proper steps. Another thing you have to do is pay the CRA. And we have a whole slide devoted to this. The tricky thing about the CRA is that it's not your life you're administering, it's somebody else's. And so there's a lot of information you don't have as an executor. And the CRA, which should be no surprise to anybody here, is a bit of a special case. They don't lose. They're not allowed to lose. The rules are designed that way. And so if taxes aren't paid and there's no money to pay it, they're going to come to you and require that it get done. And so because of that frightening possibility, there is a process that exists called clearance certificates. And that's something you can apply for, where the CRA will triple check their work and then declare, we will never revisit this no matter what happens. And that gives you peace of mind that you can pay the CRA and then forget about them forever. And again, not worth skipping this step given how uncertain tax liabilities are, because it's not your life. You don't know what's missing. Finally, when you've liquidated all the assets, made the easy payments, it's finally time to distribute funds to beneficiaries. And usually before we start cutting checks, we want to show our work to the beneficiaries rather than saying, you've seen the will, you're entitled to 20%, here's your number, you're welcome. What will often happen with beneficiaries is they will see their percentage and then they'll start doing the math in their head. And okay, there's this much property, my 20% is X, and now they're expecting that number. But of course, in the real world, we're trying to sell the condo sells for less than we wish. We're still paying the realtor $15,000 in sale fees. There's a mortgage all Untitled that no one really realized how much was owing. And so the shares can be quite a bit smaller than people would first believe. And when they get that sticker shock, they're going to blame you, even though you didn't do anything wrong. So you want to be able to show them all of the money coming in and out of the estate so they can understand how you reached that number at the end of the day. And what we ask beneficiaries to do when we give them that accounting is to sign a release saying that they're satisfied and happy with what you did. Then you can start cutting checks. And skipping that step, well, it's nice to cut checks and feel like you're done. If someone then comes out of the woodwork later and has concerns or accusations about how things were handled, you may have months or years of work to do and no money to do it because it's all been given away. So again, good to do things in the right order. So we pay our beneficiaries only when we've done all this stuff in order. All right, another common pitfall that honest people step in is failing to adequately protect assets. So the starting point there is just to understand that if you start administering somebody's estate, you do create the possibility that you will have personal liability, which is a lawyer way of saying you have to dip into your own wallet to patch holes that you make in what you're doing. So the most common risks here, the big one is insurance. So if I die, I've got an insurance policy on my house. My annual policy, I think mine's in July of every year. So if I die in, we'll say this month, I'm only a couple months away from that policy being expired. And one of the funny rules about insurance is that the policy is voided if dues aren't paid, and you can't get a new policy if unless you're the owner of the property. So only I can insure my house. My executor can't, at least until they get a grant from the court. So if you take over somebody's estate and there's a house or some vehicles, I had one recently where there were 2 houses and like 4 luxury vehicles in one of the houses. So it was extremely important that we keep those properties insured. Because if someone stole one of those cars or if the pipe burst in the house, if we hadn't reported the death to the insurance company, the policy would have been voided. If we failed to pay the premiums, it would be voided. And in our case, once 6 months had elapsed, the policy voided, and we needed to be in a position to become the owners as executors. That means having the court process, the grant of probate done. Then we had no insurance on the house. So we actually had to hustle a bit towards the end there because we ran out of time. We needed an insurance policy in place. So the first thing you have to do is notify the insurance company of the death, because that changes the risk. A house with a person in it is less risky than a vacant house, because if I have a pipe burst, I notice. If I have a fire, I put it out. If some vagrants move into my basement, I know about it and call the police. A vacant house that doesn't have that, right? So what an insurance company will do is they will actually change the policy, and they'll usually issue a rider that means you pay more because it's a vacant house. And the only thing you need for that rider to be valid is to pay the little extra fee, but they usually require that someone comes and inspects the house every day or every 2 or 3 days. And usually we get around that by having a neighbor come check or a family member come check, just to stay in line with that policy. You also need to keep the walk shoveled. If the snow melt like we've been having this year, you get a lot of melt and freeze thaw cycles. You get an icy walk, a mail carrier slips on the way up to the front steps. The owner of the house can be liable for that injury. And while insurance usually covers that, it's better not to have to go through that at all. So it's important that you keep the sidewalk clear. That's an Edmonton specific estate administration problem. In addition to insurance, we also have to make sure that we don't lose money to investments. So sometimes estates take a while, and there's an opportunity to reinvest some of the cash so that it earns a return. And if you ask your banker for advice, they're just going to give you some mutual funds or more likely guaranteed investment certificates, because they don't want you to lose money on those investments. If you take all that money and put it into Bitcoin and Bitcoin goes down, that loss is likely going to be on you. This isn't a common problem. Usually we just liquidate everything and put it into checking accounts. There's no issue there. But some people, well-meaning people who want to preserve the estate's value for everyone, can accidentally get into trouble in an attempt to do good. So just be aware of that risk. On the flip side, if it's a long-standing estate where there's some kind of complication that's going to drag things out, there is actually sometimes an obligation on executors to invest, conservatively, of course, but to invest that money so that it doesn't go down in value from an inflation perspective. So you may have $1 million in cash, but in 10 years, it's not really worth $1 million anymore because you can buy less with it. So in some cases, there is actually an obligation to invest that money. Finally, you do have an obligation to try and chase after entitlements of the estate. So let's say we lent money to the ne'er-do-well brother and never collected on it, but there was actually a written document, like a promissory note, promising that money would get repaid. You do have the ability to forgive that loan. And in fact, a lot of wills go out of their way to say, I forgive that loan. But absent that authority, it's on you to go collect that money or to get everyone's agreement to not go after it, because failing to collect a debt is the same as losing an asset, at least on a balance sheet. So simply deciding I don't want to do the work to try and bring money into the estate is no different than losing an asset you already have. Okay, so protecting assets is important, but most of the time it's enough just to notify the bank. That locks down all the accounts so no one can use the bank card anymore, and keep the house insured. Most of the time, that's all that's required. Distributions without authority. This comes up more often than I would think. You don't want to start paying debts or transferring money to people, even if it's well-meaning, until you are allowed to do that. So a very common thing I'll hear when I speak with clients early on after a person's died is I'll mention that we might have to go talk to the bank to get the funeral costs paid. And they'll say, oh, no, it's okay. I have power of attorney. And I usually have to inform people, well, a power of attorney is revoked on death. So you may have been managing this person's money last week, but since they've died, you lost that authority. And now we have to take that will to a court and get a grant of probate before you are empowered again to deal with that person's property. So even if you have access to that person's accounts because you used to have a power of attorney and the bank hasn't been informed yet that they've died, or if you happen to have their bank card and know their PIN, or if you know their online banking password and have been doing their banking on the computer already, or if you, I'll skip the last one for now, just because you are able to transfer money and move it around doesn't necessarily mean you should be. Now, if you have to pay the property taxes on the house or the insurance, that's okay to use these sort of backdoor routes. My preference is to do it in the sunlight, where you go to the bank and say, this person's died. Can you, bank, please make these payments? Here's the funeral cost. Can you write a check to the funeral home? Because at least no one can accuse you of doing anything behind closed doors. Let's say instead you took advantage of your knowledge of their online banking information and transferred $10,000 to yourself because you paid the funeral cost out of pocket. That's fine, strictly speaking, right? Like, you weren't supposed to pay that funeral. You were entitled to a reimbursement. But when you're trying to explain this to the other beneficiaries, there's a big difference between saying, here's the invoice for the funeral, I paid it, here's the credit card receipt, the bank reimbursed me, and there's a reline on the bank statement showing the money went to me for that reason. That looks very above board. But if instead you simply say, oh yeah, I paid myself 10 grand, but it's okay, it was for funeral costs, people are going to be more suspicious, even though you really haven't done anything wrong. Better to do it in the more formal, appropriate way. That last note about joint accounts and beneficiary designations, it's really common these days for people to name their executor, who is often also the power of attorney, and make them a joint owner of some of the major bank accounts, or to name them on a life insurance policy. The thinking being that cash will be available right away, and they can use that to pay for funeral costs or other sort of front-end expenses after a person dies. And that's not a bad idea necessarily, but it does just create complications where people, the beneficiaries, won't really understand what you're doing and why. So if you are a joint owner of their checking account and you just inherit $50,000 immediately and you become the owner of that account, in your mind you might say, well, this isn't my money, this was money that I was just added on the account, and so I'm going to pay funeral costs and do the honorable thing. But the relatives might see that you are suddenly the owner of this checking account, and they'll get really upset, saying, why on earth did you just get this present from the estate? Why would she give you this money over top of what you're getting in the will? This doesn't feel right. And so it's usually better to, again, do things more slowly and more transparently, even when we're using shortcuts like life insurance designations or making someone a joint owner. Now, just because you're named in the will and it says you're executor, that doesn't actually empower you to deal with the estate fully. You're the presumptive person representative, but until that goes through a court and they give a grant, that's not confirmed. Similarly, if there isn't a will, but you're the next of kin, that doesn't mean you can start dealing with their property. There may be someone with a higher right. I had a file over this past COVID year where a person died. He had a surviving spouse and a young child, and there was we couldn't find any will. So we got started on the estate as best we could, and had a lot of business. The guy owned a lot of rental properties. We were doing our best to manage those. And then some daughters from a previous relationship suddenly came out of the woodwork. And it turned out he had an old will that had named them as the executors of the estate and had given them all the property. And here we were assuming that we were the only people interested in the estate. We were the surviving wife and small child. But there was actually a competing interest that had to be measured. So it was a good thing that we had done everything by the book, because if we had been moving money with online banking information or knowing a PIN number, they might have suspected us of being up to no good. But as it happened, we were doing everything by the book. And so it was very easy to explain it all away. And we still haven't figured out who's going to administer this estate. But you never know what'll happen. You never know what wills are out there that just no one's told you about. But in any event, until we go through that court process and a court ratifies the will and says, yes, this is the last will and testament, this is the executor who's going to run things, and this is how the distribution is going to go when things are done. Until you get that, you're acting on apparent authority, not actual authority. So it's important to tread lightly and be careful and not do irreversible things. Number 4, kind of the same thing I was just talking about, but I'm making the CRA its own special case because it is special. The CRA has what's called a super priority, so they get, even regardless of when the tax debt came into existence, it gets to jump the queue and go ahead of other unsecured debts just because they're the government and they don't lose. It's also important to remind you again that an executor is personally responsible if there isn't enough money to pay the CRA because you have sent money to somebody else in the improper order. Now, this doesn't happen a lot, but when it does, it usually is happening to a person who just didn't realize and wasn't doing it on purpose. It was an honest mistake. But the CRA doesn't really care how honest or dishonest you are. They just want to make sure they're paid. So what can happen sometimes with CRA debts, because it's not your tax world, you don't know it, and so it's easy to not see things coming. So it's very easy to say, grandma is living on a fixed income. She has old age security and CPP. She has very modest investments. Most of it's just cash in a checking account. So there's really no income. I don't need to plan to pay off a big tax bill. So it's okay for me to give an advance to this nephew on the will. I can give him the money early because we have lots of money and there are not going to be any taxes. Well, oops, if there's an RSP or a RIF and it's being paid to the estate, there's a good chance there's going to be a tax bill as high as 30 or 40% of that money. And the reason for that is that RRSPs, as we all know, you get a rebate when you put money in. And that rebate is designed to simulate that money is pre-tax money that we're investing. So when we pull out that money, not only do we have to pay taxes on all the gains we've made on our investments, but the money we started with, the principal, also gets taxed. And so that often means is there's some sticker shock when a person dies with money in an RSP or a RIF, because that's pre-tax money that's been invested. And so the numbers are higher than people would expect. Again, often as high as 50% of the money. And it can often be overlooked and people don't plan properly around that. Similarly, if you've got an asset that's been in the family for a long time or is a complicated business asset, there can be some pretty big capital gains that people don't properly anticipate. So let's say you inherited the ancestral family farm, nice little quarter section up near Three Hills, and it's been in the family since the settlers moved out on the new railway. They paid $5 for it, and now it's worth only $300,000. You may not realize it, but no taxes have ever been paid on that piece of land because it's been passed down through the family and used as a farm. Well, now that you're the executor inheriting it and it's being sold, the gain you're being taxed on is that whole gain, not just $100,000 since they bought it, but from $5. It's the full value of the property that's being taxed. Now that tax is probably only going to be 25% of the value, but again, it can be a surprise amount that people aren't planning for. And if we're trying to keep that farm in the family and we don't want to turn it into cash and liquidate it, there might not be enough cash to pay every expense of the estate and the taxes without selling the farm. So again, you have to be mindful of assets like that. Similarly, if a person owns shares in a private business, there's often some surprise tax complications. So we don't want to write those off. And finally, and this is surprisingly common, usually if a person's quite elderly and someone else has been filing their taxes for them and we take over their estate when they've died, we have a fairly high amount of confidence that they've been filing their taxes over the last 10 years. But if you haven't been involved in that person's life and they're elderly and there hasn't been a power of attorney working on them, they may have just forgot to file their taxes for 5 years. And even though their income is quite modest, the unpaid amount when you compound it over several years with penalties can be quite a bit. And again, if you're kicking out checks to beneficiaries early because it's COVID and they really need money and you're just trying to help them out and be a good person, you may find yourself with not enough cash left to pay the CRA. And then you have to either dip into your own checkbook or go back to those beneficiaries and say, pretty please give some back. I made a mistake. All right. This is the biggest one, is accounting records. And the reason this one causes so much trouble is because it's a pain and no one wants to do it. So the advice you'll probably get a lot from lawyers and funeral homes is, if you are going to administer an estate, you have to keep meticulous accounting records. And this is not something people do naturally unless they're already an accountant. Most people just get a big bag or a binder or even a shoebox and just stuff all the receipts in and go, there we go, I'm accounting for things. And that's better than nothing. But ideally, what you should be doing from day one is anytime a thing is getting paid that the estate should be paying for, anytime money comes in, you should be keeping a spreadsheet and logging each one of those transactions with the date it happened, the amount of money coming in or out, what it is, and whether it's something being paid directly to someone or if it's a reimbursement because someone else paid it. And the thing about estates is, this isn't your one and only job. This is something you're doing during your regular life. And all of our regular lives are busy. And it's hard to keep this on the back burner and do a good job throughout the sometimes year or 2 years it takes to administer an estate. So we may do a really good job in the first week of recording these, but then we start to get sloppy or bored, and we start to make mistakes and leave things out and go, oh, I won't forget that. I'll remember that I reimbursed Paul for paying that stuff. And then 2 years later, or heaven forbid, if you get sick or die yourself, it's someone else who has to reconstruct what happened and why. So it's good to do this from day one and do it well throughout. And if you're not up to the task of doing it, you can definitely take advantage of using the local bank branch that's holding the estate money and just having them make the payments, going to them and saying, could you please pay the funeral expenses? They'll go, good, give me the invoice. You'll give them the invoice. They'll pay exactly that number. And then on the bank ledger that you have access to most of the time, it'll say, on this date, we paid this funeral home this number. And in a lot of cases, they'll actually keep those invoices to prove that they were right to do it. And that can really help when it's been a year and a half. We don't remember exactly what happened in the few weeks after the death. So I'll give you an example of what this can look like in a typical estate and why it can be a bit intimidating, but it's definitely worth doing. So this is a made up estate that I did when I was preparing this presentation. It's actually pretty similar to what a normal estate will look like, in that we've got a number of sources of funds. Typically, we have some bank accounts to start with. We liquidate some investments. We get funds from a separate bank and we move it into the main one. We sell a vehicle. We sell a condo or a house. We get life insurance proceeds. And it's good, again, to track the number and put some kind of entry to remind us what it is. If you simply say deposit and it's 3 accounts from a different bank that all came in one check, it can be hard to reconstruct, what is this? Or more importantly, did we get all the money from this bank account? We can't tell because this just gives us one check. Weren't there 3 accounts? And so you want to keep good records to help with that. Similarly, you want every expense, even small petty ones that don't seem worth doing, to be logged. And so I left a couple in here, right? We have funeral costs. We have reimbursing a person for whatever expense. In this case, I chose flowers for the service. We had some taxes payable, some professional fees, and we paid out some money to a beneficiary who was entitled to a specific sum. You do want to keep track of these $7 charges. And the reason for that is, at the end of the day, when everything is done, when you go to the beneficiaries and you tell them, here's what your 1/2 or 1/4 is worth, you want to show them how that number was arrived at. And you need to have that to the penny. If you're just saying, well, we received about 100,000, we paid out about 25, so we have about 75. Here's your 1/3 $25,000 check. And they might say, well, I was expecting closer to 35. What happened? And you can say, there were expenses. And if you don't have a clear, immediate answer, they're going to start to assume something's untoward, even if there isn't. And if you keep records like this, the key is, if you're keeping a running balance like this, and at the end of the day, this running total is exactly what's in the bank account, then you've done your job right. And you're not going to get any complaints from beneficiaries if it is to the penny accurate. I had one, we wrapped this up just last month, and it's an estate that's been going on for over 10 years. And this accounting spreadsheet was developed from what we had to do in this thing. And it had over 1,600 line entries, including bank fees, 250. And when we finished it and we added up all the columns, the numbers were just completely wrong. And so we had to go to the beneficiaries and say, you guys want to just trust this? The columns don't line up, but we're sure we didn't make any mistakes. This is what we have in the bank today. So can you just trust us? And of course, he said, no, we can't do that. So we had to go back line by line and debug this 10-year long spreadsheet, looking for what ended up being finger slips, where a number was inserted by accident when a person was just hammering in these values. And that threw the numbers way off. But once we found them all and cleaned it up, it was to the penny exactly what we had in the bank. And so when we went to these beneficiaries and said, here's the final number, here's how we got to it, it is to the penny accurate, they had no questions. Even though there were some transactions that they could have asked about, they didn't care. They just were happy that it balanced in the end. So if you aren't up to this task, you can ask a lawyer to do it as part of their job as advising the estate. I used to recommend that people did this themselves. I did that for about 5 years. And more recently, I'm now really encouraging people to let me do this. And the reason for it is you can move all of the money that's in 2 or 3 banks that a person has and the life insurance policy. You get all that payable into my trust account. I'll go backwards. Ideally, run this out of a law firm trust account. So what that means is, whether it's a funeral cost or a lawyer bill or paying some taxes to the CRA, no money leaves my office unless I know what it's for and why and have documentation to support it. And that I'm keeping a running spreadsheet going like this one. That way, when everything's said and done and we're ready to give money to the beneficiaries, not only do I have a good spreadsheet like this that is to the penny accurate, if anyone asks me a question about any one of these line items, I can pull up the invoice or the bill of sale for the vehicle, and I'm able to explain to them why that number is what it is. And when you have immediate answers to questions, people tend to back off more quickly because they're less suspicious. Which is a great segue to what I think is the single largest cause of disputes and fights in estates, and that is inadequate communication. Even if you do everything right, that does not stop someone from hiring a lawyer and demanding that you produce accounting records or demanding or accusing you of doing something you didn't do. I get calls on both sides of this issue. I get people who call me and say, I am convinced that this person is stealing money from the estate. I haven't heard anything in 6 months. I want you to look into this and get to the bottom of it. And I usually caution these people and say, when I look into this and get to the bottom of it, there's a very good chance my answer is going to be, they're doing everything right. And then when I look into it, sure as shoot, that's what happens. And people usually aren't happy with that answer. But that is just the nature of estates. And the reason for it, I'm sorry, I'll talk about human nature, not law for a bit. If you leave a voicemail or a text to a friend and they don't get back to you, the logical side of your brain will tell you the reason for that is they just forgot or they were busy. But that's not what your brain's going to do. It's going to say, oh, they're dead, or they've been kidnapped, or they're mad at me. This is just how we're wired as people. And that dynamic is especially prominent in estates because there's a lot of information that's unequal. If you are inside the process, talking to the lawyers, talking to the accountants, seeing the bank records for yourself, you know you're doing it right. But for people who are outside of that process, and all they see is silence, they're going to wonder what's taking so long. And that absence of information will always be filled with the conclusion that you are stealing money and covering your tracks. That is just how people are wired. So human nature, as I put here, if they don't have information, the conclusion will be something bad is happening, and they'll assume it has agency. Someone's doing it. It's not just the way things are. Most of the time, if an estate takes a long time, it's because RBC is being a pain in the ass, and their estate department in Ontario is taking a long time to process the request for information. That's a boring explanation, but most of the time that's what it is. We're just dealing with some bureaucracy somewhere in Canada, or we've had the lawyer is busy and hasn't replied to a request, or you're busy and you haven't replied to a request, and stuff just takes a long time. And that's part of this process. It doesn't mean anyone is up to no good. So how do you counter that? What I recommend people do is take what I call the town crier approach, which is even if you have nothing to report, send an email to the beneficiaries and say, hey, quick update, I have no news. We're still waiting on this. Or here's what we're doing. You probably don't care about any of this information, but I'm just going to dump it on you. Because if you are frequently communicating and saying what you're doing, even if it's boring and unimportant, when the time comes, when you ask beneficiaries to sign off on the work you've done, they're going to just conclude, well, they've been emailing me every month for a year, so I'm just going to go ahead and assume everything's fine. I'll sign the document, and then we can move on. So I strongly recommend that, because the alternative is keeping people in the dark, and that just breeds suspicion. So again, even if you are doing everything right, even if you're communicating well, that doesn't stop a beneficiary from being cranky, calling a lawyer, and causing trouble. And they, even if you answer all their questions and they're still suspicious, they may demand that a lawsuit get started. And even if you win that lawsuit handily, the fact that you went through it is a punishment on its own. It was a lot of time. It was money that came out of everyone's pocket, although hopefully the complainant, not everybody else. And the only way to really immunize yourself against that risk is not to be on the right side of the line of behaving appropriately. It's to be so far past that line, to be beyond reproach in everything you do, so that if someone goes to a lawyer and wants to start a lawsuit, that lawyer will laugh them out and say, don't waste your time, don't waste my time. That's what your aim should be. So do everything right, follow all the steps in the right order, and do everything by the book, communicate throughout. And ideally, you will have bored all the beneficiaries to tears, and they will be just delighted to receive a check and sign something for you. So that's actually all I've got for today. Only 45 minutes, but that was by our plan. We wanted to leave a lot of time for Q&A, and I certainly saw a lot of hands pop up on this display. So I'll open the floor to questions through our moderator.
Yes, that's right. Thank you. If you've got questions, please put them into the Q&A function, and most of you, that's at the bottom of your screen. We do have lots of questions coming in, Ben, so there are a number of them that are very case specific or very unique to a particular individual. So for the sake of privacy and we probably won't go to those questions. We'll go to questions that will appeal to most of our listeners. We've got over 220 people on the call right now, so we want to make sure that this is relevant for as many people as possible. So this question actually made me smile a little bit. We titled this presentation "How Not to Get Sued," a bit of a tongue-in-cheek title, and you explain how this is just sort of in fun. But an interesting question: who might sue an executor? If you were going to get sued, by whom?
Not a short question, unfortunately.
Give us a quick, give us the Reader's Digest version.
The short answer is anyone who isn't receiving something they should have received. So usually that means beneficiaries, people who are named in the will. Sometimes it'll mean claimants, like the CRA or the credit card or the line of credit. And that's why you want to go through the process sequentially and do it by the book, because if you act, especially this year, a lot of people will say, times are tight. I lost my job. I have lots of bills piling up. I'm entitled to somewhere between $30,000 and $50,000 from this estate. Can I get an advance on that? And a lot of executors come to me and say, can we do this? And the answer is usually yes. I have an extremely high confidence that we can pay them, that they're going to be entitled to at least $50,000. So you can give them 10. Or 25, because I don't want you to accidentally give too much, so that when the time comes to make all our payments, we're short. So that's the first answer, is people who are entitled to money and you've accidentally directed it to places where someone got money who shouldn't, or got more than they should have. The other source of lawsuits are more procedural, which is you may read the will and interpret it a certain way, and you might say, well, the will leaves everything to the kids, and there's a spouse, but they've been living apart for a year, so I'm just going to cut them out of the process, and I'm just going to work with the kids because that's who I want to get the money. And that spouse may have rights in the estate, and if you try and dodge them or go around them, they may hire a lawyer and come after the estate. So again, if you follow the process and get good legal advice, you won't get into these problems, but so long as you follow the process, you're usually okay.
Great, thank you. Are there places where executors could check what assets the deceased owned? There's some websites or some resources that you recommend to your clients?
I hate that the answer to that question is no. Now, back in the day, 10 or 12 years ago, before everyone got their statements by email, the system you could always rely on was if you waited patiently and let the mail come in, you would get statements for every life insurance policy and every investment brokerage and every bank account they have. And then you go check those. Now a lot of it comes in by email, and so it's easy to miss those. Now we can do name searches for things like land, but most of the time the only avenues we have are just going through the papers of a person and seeing what comes up and then calling those agencies. So there is always a risk, and I especially feel nervous with some of these purely online banks, like I think Tangerine is one of them, and they're perfectly fine to deal with. But if the family doesn't know there's assets there, because all of the communication happens online and there's no physical brick and mortar store you can go into, there's always that risk that that money just won't be collected until someone notices it. Though I should say this isn't a new problem. I mean, I've seen files where a person dies in the 70s, and then 40 years later, someone gets a letter in the mail that looks like a scam, but isn't, that says, hey, we're from an asset reunification company, and we believe that you are the next of kin for these assets, these share certificates that no one claimed 50 years ago. And that does happen. And it's just because there's no, what the question is prompting, is there some kind of centralized database where we can see where your assets are? And the answer is no. If you have a piece of paper and that's the only representation of your ownership of that share, and no one finds it, it is sort of lost. That's why it's good to keep things in a safety deposit box or make a list somewhere so that people can follow it, or just consolidate, right? If you have assets in 6 different banks, make it one so that we just have to go to one bank and they'll tell us everything.
Sounds great.
Good question though.
Yeah. And speaking of banks, you talked earlier about an estate bank account, and then you showed us that accounting about 2 or 3 slides back. Does that mean that executors should set up a special estate account in the name of the estate, or can they use the existing account for all of that accounting?
That's a distinction without a difference, actually. So what normally happens when a person dies is you'll go to that person's main bank branch, the one where they do their basic banking. And if you go there and provide them proof that this person has died and you have a copy of the will and you're the named executor, what they will usually prompt you to do is fold all of the various accounts this person has and push all that money into their checking account. And then that checking account will be flagged by the bank as a quote unquote estate account, which is not a real thing, but they flag it. They all have their own ways to flag it. And what that means is this is where all the money will be deposited and this is where all the money will come out of. And you need to have an account like that for a couple of reasons. Because you can, one solution is just to have everything in joint name so it goes over to a surviving owner. But the problem is you're going to get checks payable to the estate. You're going to get that CPP death benefit of $2,500. It's going to be payable to the estate of. And so you need a bank account where you can cash that check. Similarly, a life insurance payout that doesn't have a beneficiary or names the estate will be a sizable check payable to the estate of. And so it's helpful to have that account there for you to deposit money. And while you're waiting for a grant, banks are usually quite gracious. And they don't even charge for this, but they will make appropriate payments for things like funeral costs, like professional fees, like making sure the mortgage is getting paid, the property taxes are getting paid, and the utilities are getting paid. And then once you get that grant, then you no longer need to use the bank as a go-between. You are the go-between. You move everything into your name with a comma after your name saying, comma, personal representative for the estate of. And then you don't have to be second guessed or provide proof. You can go on your own discretion.
Right.
But yeah, that's a thing you should do. And in the absence of doing it in a bank, you should push it into a law firm because we're a little bit more accountable and a little bit easier to deal with.
Excellent, great. In your experience now during the pandemic, how long is it taking to get a grant of probate?
Depends which jurisdiction you're in. In Edmonton, at the beginning of COVID, it was about 3.5 to 4 months. And then all the courtrooms closed because of COVID. And so all the clerks didn't have to go to courtrooms and they were at their desks processing estates. And so it actually sped up to under 3 months. It was really fast in spring and summer of last year. But now it's starting to slow down again and we're back to about 3.5 to 4 months. But if you're in a smaller jurisdiction, like, I don't know, Wetaskiwin or Peace River, those can actually be quite quick sometimes because they have a person who's trained to do this, but they have less than fewer estates than that are needed to fill that person up. So it really depends, but 3 to 4 months is usually what I warn people to prepare for, which means you want to get that filed quickly so that you can do the other work in the background while you wait for the courts to process it.
Great. I'm going to read this question because I think this, I have found that this creates a lot of confusion for people sometimes from our Wills Week sessions. Can I leave my RSP in my will to my nephew without having any tax implications for the estate or him? I know this is a big one for people and their RSPs.
Yeah,
Walk us
RSPs
through that.
are tricky.
Mhm.
And so I'll have to answer that question by giving you the full primer on how they work. As I mentioned before, RRSPs, and if they turn into a RIF later, they carry a lot of taxes in them because you're putting money in and getting a rebate so that it simulates pre-tax money. And then you're earning a return on that money that it also has to get taxed. So the goal, what your investment advisor is probably telling you to do with those, is if you're spending any of your investments, you spend that first. Because if you draw it out slowly and gradually, your income is much lower when you're retired, and so the tax is quite small. But when a person dies, they are deemed to have sold everything they own at fair market value. So what that means for an RSP is if you built up $250,000 in there and then you pass away, then instantly all of that money has to come out. And that's the same as earning $250,000 in 1 year plus any other capital gains or income you have in that year. So the effect is you're taxed really, really high if there's money left over when you pass away. Now, one of the ways you can get around that is if you name a spouse as the beneficiary, because if we give our spouse an RSP, there are special rules designed to let that happen on a tax deferred basis. So if I have $250,000 in that RSP or RIF and I give it to my wife, there's no tax payable. She inherits all that loaded that RSP with that loaded tax in it, and then she can draw it out slowly throughout the rest of her life. But if I'm giving it to my nephew, I don't have that option to give him the money with the tax burden built into it. It has to be paid. Now, that can cause some complications, especially when the will says he gets it, because it's really important that the will address the question of who pays the tax, because there's very good arguments going both ways as to who should do that. On one hand, he's getting this $250,000 RSP. Why would the estate pay as much as $100,000 in taxes on it just so he gets that money free and clear? Is that really what was intended? On the flip side, why shouldn't the estate pay it? The intention was to give him that value, and now he's going to lose a third to a half of it. Is that really fair? And so it's good for a will to answer that question, so there's no room for a fight, because the default rule is the estate pays it, but it's really easy to convince a judge that it ought to be the recipient. So it's a long answer to a short question. The general rules are try to spend your RSP money. If you're going to take any money out of an investment, do that one first. If you have a spouse and you want to leave money to your spouse, as most of us do, definitely make sure that that names them. And then if there's no helping it and it has to go to your estate or to someone else in your family, try to make sure in the will that we have addressed the question of who will bear the cost of that tax, so that no one can fight over it.
Sounds great. Thank you. I'm seeing a couple of different questions here about executor compensation. So are they entitled to it? If so, does it get stipulated in the will? Is it percentage based? And then another question is, can beneficiaries contest the compensation? So let's talk a little bit about that in general.
Several bullet points. You should have written all that down. That's a good question, because it's very thorny and not really written down explicitly anywhere. So executor compensation, are executors entitled? Yes. Even if will doesn't say so, even if it's a small estate, executors aren't expected to do the work for free, especially considering there's often claimants like credit cards or banks that are owed money. And if no, why should they get someone to work for free to make sure that money gets paid to them, right? In fact, they can do the work themselves if no family member steps forward. But yeah, they are entitled to it. As for how much, this is one of those areas where unfortunately courts have decided the best arbiter for that is not some table somewhere on the internet. It's whatever is reasonable, and only a judge knows what's reasonable. Now, that being said, a bunch of lawyers got together in Alberta a couple decades ago and created a set of guidelines that they thought was appropriate. And they are formula based, and they use the value of the estate to calculate what's reasonable. And I have seen lots of decisions by judges where they go out of their way to say, there are these rules out there, and I want to caution everyone that those rules are not legally binding. They're not made by the government or legislatures, and so they have no legal standing. That being said, in this particular case, I think they're perfectly reasonable and I'm going to use them. So are these things legally binding? No. Are they right most of the time? Yes. The bigger the estate, the smaller the percentage is, but the larger the sum is. Very commonly, it's in the $10,000 to $20,000 range, just for estates that are in that $200,000 to $800,000 range. So that's the first question. Second question is, how can it be contested by beneficiaries, and how do we actually go on claiming it? And so the answer is, unless you go in front of a judge to specifically answer the question, you will not get a straight answer. Most of the time, all we do is in that last stage of an estate, when we go to the beneficiaries to show them our work, we will ask them for compensation. So we'll say, here's all the work we did, here's the spreadsheet, and we think $15,000 is appropriate. So we put it in the spreadsheet. And if you approve the accounting, which includes that payment, then we're good to go. And most of the time, I find people ask for very little, less than I recommend that they ask for. And most of the time, people approve it without blinking. That being said, especially when families are larger and there's some discord in there, then people will latch on to that to attack the executor and use it as a proxy war over who spent more time with mom in the last 5 years. So yes, the way you contest it is you simply don't approve the accounting. And then the executor has to go to a court to get them to approve it, which will include a review of how much compensation is being sought. I hope that answers the question.
I think so. I think it covered the points anyway that were in the question. So we'll say yes. Yeah, hopefully yes. But I think we should mention that that compensation is considered taxable income.
Yes, so I should have said that for sure.
Yeah.
A lot of people don't, and that's bad. You shouldn't do that. But it goes onto your income. So very, very often, actually, doesn't make sense to pay executor compensation. So if you're already receiving half of the estate, if you take compensation, half of that's coming out of your own pocket, and then you're paying 40% tax on it if your income's high. And so you're really just giving money to the government instead of yourself.
Right. Is there a statute of limitations on collecting debts for an estate?
I'm not clear if that means money that is owed by the estate or to the estate.
I think it's owed to the estate.
Yeah, I'll answer both because they're both.
Yeah, okay. Yeah.
So if an estate is owed money from brother Phil, who often needs to borrow money, the normal statutes of limitation definitely apply. Now, the 2-year statute of limitations is tricky because there's no question that it's 2 years. The real question is, when does that start ticking? And usually it starts ticking from when there's a refusal to pay or a deadline has been missed. So if you just lend the money, and if you're really responsible, make a promissory note so there's a record of it, unless that promissory note has a due date, that timer doesn't start ticking until he refuses to pay. So usually there really isn't one for the estate to claim money from somebody else. Now, as far as money that is owed by an estate, again, the same rules apply. So if a lot of time has passed, you don't have to worry too much about people coming out of the woodwork. However, there is a mechanism you can use if you are just worried about there being debts by the estate that you don't know about. Because again, you are personally liable. So if you've given all the money away and then a valid debt comes out of the woodwork, you've got to pay that debt. So one of the processes that exists is, and you may have seen this in the newspaper, if you run ads in the paper at least 1 week apart, and it's published in the newspaper in the city where that person lived, then I can't remember the amount of time, I think it's 3 months. If people don't come forward and make claims on the estate, that debt is discharged. So that is one way to immunize yourself against those.
Okay, great. There's some questions here around some registered assets, TFSAs, RSPs. Can you talk about the difference if there is a beneficiary named on these versus when there isn't, and how that works?
Yeah, so when you've got an RRSP or a TFSA, people often name beneficiaries, not in a very deliberate way, because they open the account and the bank puts a bunch of papers in front of them and says, fill these out. And one of the questions is, who gets this money if you die? And so not a lot of thought goes into it, but the good news is most of the time when a person fills that out, they're going to put their spouse or their kids or basically whoever was in their will anyway. So mechanically what happens is when I die, all of those accounts that name a beneficiary, that money goes to the beneficiary, and it goes by way of contract between me and the bank. So I have a TFSA with my bank. I name my wife as a beneficiary. So once someone provides the bank proof that I have died, they're just going to go ahead and pay my wife that account, full stop. Same goes with an RRSP. So even if my will says something differently, if it says I leave everything to my kids and I don't mention my wife, she's still going to get that TFSA because the will doesn't override the beneficiary designation that I made. The beneficiary goes first because it's a deal between me and the bank. So the bank is just doing what I already told them to do. Now, that being said, depending on the language in the will, you are able to change those beneficiary designations by saying, I would, and this is actually a very common clause, I want all of my various beneficiary designated assets to go to this person. And that does have the legal effect of changing them. And so long as you don't change them on the account again later, that does hold up. Now, there's a problem with that, is that legally, if I name my wife in the will saying she gets all my beneficiary designated assets, but I don't actually physically change my TFSA that I opened when I was 16 and named my mom, even though my wife is now entitled to that asset, the bank doesn't know what I wrote in my will. So they may go ahead and just make the payment, and then we have to try and go back and set things right. So what I always caution people is, I don't like to do wills that change beneficiary designations. I just want you to go and change them so that they match what's already in your will, ideally. And then the last comment on this, because we mentioned that a little bit earlier, is when it comes to RRSPs, TFSAs, there's no tax, but RRSPs there is. And it's a very live issue about who is supposed to pay the tax attributable to that asset. And I always want that question to be answered before a person has died, when you have some say in it, as opposed to after the fact, when the two sides have very different opinions and very self-interested opinions about who should be paying that tax, because it's a $100,000 question sometimes. You don't want the lawyers to get all that money. You'd rather it be answered already.
Sounds great. Thank you. I'm seeing some questions about executors out of province. What are your thoughts about that?
A lot of thoughts on that. So the first one is that sometimes when we're picking executors, I always tell people you want someone who's close, both in terms of intimacy and geography. So you want a friend or family member, and you want them to be in Edmonton or failing which somewhere in Alberta. Now, sometimes the only good candidates are family outside of the province, and that's okay. Now, the only complication there is that when a court issues a grant to a person who's outside of the jurisdiction, there is the fear that that person can then go to the bank and say, great, I have a grant. It's time for you to move the money into my name. And then they go to land titles and they say, nice house, put it into my name and I'm going to administer it. And then if that person starts doing inappropriate things or acting badly, it's very hard to undo that because they're outside of the Alberta jurisdiction. So courts, the default rule is that that person should post a bond. Usually the estate pays for this, but it's basically an insurance policy that will pay out the beneficiaries if the executor absconds with the money. Now, of course, that doesn't happen very often, in large part because there are safeguards against it, like this bond. But that's the presumption. For that reason, whenever I'm naming a close friend or family as an executor, we go out of the way in the will to say there shouldn't be a bond. I trust this person. They're not going to run off with the money and screw my family. And most people are decent, and that doesn't happen. Now, that being said, logistically, you are causing some problems for out-of-province beneficiaries, especially if you go international. So if we have executors who are in the States, for example, when it comes time to liquidate investments in a non-registered investment account or even an RSP, even if you have a grant, which gives you the power to do that, the mechanics of liquidating an investment account requires that you give directions to a broker, and brokers have a lot of rules that require that they take directions from someone who is in their jurisdiction. So very often we have to get two banks involved so that they can go to an American bank to sign some forms to send to your Canadian bank, and it's a real headache. So if you can avoid beneficiaries outside of the jurisdiction, it is so worth it. Sorry, I meant to say executors. But if there really isn't anyone, it's okay. These are just hoops you have to jump through. It causes problems, sure, but that's better than having no executor. Now, one last comment on that. There are professional executors out there. Some lawyers, if you really twist their arm, will agree to do it. And then every major bank has a trust department that handles estates. They're very good, but they're priced accordingly. So they're expensive, but the nice thing about banks is that they have every nationality they need, and they don't have any problem with jurisdictional issues. So if your best candidate, if all your beneficiaries are in the US and your best executors in the US, and you have lots of money and don't really care if a 5-figure sum goes to your bank, hire the bank, they'll do a good job, and you don't have to worry about any of that jurisdictional stuff.
Sounds great. This next question is actually probably best suited for our Wills Week, but you and I know that we get this question at every single Wills Week session, so I'm going to ask it here, even though it's not executor specific. Is it beneficial to add a child to land title to avoid capital gains if they are to be a beneficiary?
Noel isn't lying when he says we get that question every year at Wills Week.
I saw that you actually adjusted yourself in your chair. Like,
I was going to say, if someone doesn't ask, I usually go out of my way to tell them, because this one's my personal crusade. Stop adding your kids to title, please. You can't dodge probate. That's not a thing. This is not Ontario or BC. You probably have relatives in Ontario and BC who tell you probate is a nightmare. It costs tens of thousands of dollars. That's true in those provinces sometimes. Not here. Our probate fee is capped at $525. Do you really want to cause complications and difficulties over such a small sum of money? Now, why is it bad to add a kid to title? There's a couple. One is similar to that RSP question, is it invites uncertainty about who gets that house. So let's say my will says everything to my 3 kids, and then I name one of my 3 kids on title. Are they just holding that for the other 2, and they're supposed to give it back and split it 3 ways? Or is it theirs to keep? That I don't want to have that fight. That's a disaster waiting to happen. The second one deals with something called the principal residence exemption. So everyone intuitively knows that there's no taxes payable on your house when you sell it, but not many of us realize that that's only because there's a specific exemption carved out in tax law. In fact, anything I sell is taxable, but my house isn't, because there's an exception for this. And the way that calculation works is, when I sell my house, I declare how many years it was my principal residence. And if it was all the years I owned it, all the gain goes away. The trouble is if I have co-owners, they have to claim it too. And that's fine if it's your spouse, because it was their principal residence in those years too. But if you start adding your kids, and heaven forbid, all of your kids, from the year you add them going forward, if you have 3 kids and you're one owner, there's now 4 owners, and only 1/4 of that house is tax sheltered until it's sold. And that is an unfortunate loss that people don't think that they're walking into, and all to avoid this boogeyman of probate that isn't really a problem. So my always advice is, when it comes to all tax planning and adding people as beneficiaries or joint owners, add your spouse. Do that to everything, but stop at the spouse. Let the will govern everything downstream from that step. And that's almost always the right answer.
Sounds great. Thank you. Yeah, it always comes up, so I thought I would ask it. There actually are a number of questions here about what the executor can and can't do with regards to selling the main property. So since we just talked about the main residence, let's stay on that vein. Does the executor choose the final price of the property? Can the other beneficiaries argue on the price? Do they have to agree on the price?
Unfortunately, the answer to all those questions is yes. So I'll walk you through the nuances.
Mhm.
But the starting point is usually that the executor has unfettered authority to sell the house and set the terms and set the price, but they're accountable for the decisions that they make. So that's why I sort of say it's yes to everything. So do you need to check with all the beneficiaries and get them to approve the sale price? No, you don't. You are able to convey the property to a buyer without checking in, but you're accountable for that decision. So when you get to that accounting phase at the end of an estate and you say, here are the proceeds from the sale, and it's in my spreadsheet, and that's part of our calculation for what you all get. If someone says, well, hold up, this was a $500,000 house, how on earth are the proceeds 250? And if the answer is, well, because I sold it for 3, because I sold it to my brother, you're going to have a problem. And if they take that to court, you're probably going to get smacked by the judge and have to backfill the hole that you created by selling to a friend under value. But if instead, well, we listed it for 6 months, we kept reducing the price on the recommendations of a realtor. It was listed at $425, we got an offer for $4. We accepted it because that was reasonable. Realtor fees were $15, and there was a little line of credit that got taken out 5 years ago by mom, and that was $35. And so now it's only $350. People might complain about that, but they don't really have a leg to stand on because the price you picked was entirely reasonable. And if they tried to go to a judge and ask that you personally be liable for that difference, they're not going to succeed. And no lawyer is going to take the case because what you did was entirely reasonable. So that's the nuanced answer to that question.
Excellent. Great. It sounds like being an executor is a really big job. So what are the pros and cons of having more than one executor or co-executors?
That's a really good one, because pros and cons is the right word for sure. Mm-hmm. There are a lot of advantages to multiple executors because it's a lot of work. They can divvy it up. They have someone that they can check in with and get second opinions on, because when you're flying solo, it can be quite frightening and not having a person to bounce ideas off of. You can always hire a lawyer or an accountant, and that helps having someone. But more than one body can be very helpful. And I always tell people that whether you name them or not, you can always expect that the spouse of the executor is an informal co-executor. And that's just the reality of how things are on the ground, right? They will do it together. Now, naming 2 siblings as co-executors can help with that. There are a lot of reasons not to do it. The biggest one is if they don't get along or work well together, you're just putting them in situations where those divisions will come up a lot. If you name an even number of co-executors, it's possible to have a deadlock, and the only way to resolve the deadlock is getting a judge to weigh in. And if you're doing that, everyone's losing already because of the cost and time. It can also be problematic if one of the 2 co-executors is in Edmonton, and so they have boots on the ground. It can be physically present to sign things and attend to things, but the other one's from a different jurisdiction. So now we have difficulties where we can meet one person in person to sign something, but we still have to send documents out to Ontario to sign remotely. Or we have difficulty getting written directions to banks because, again, they have to meet in different cities. And if they're really outside the jurisdiction, all those complications I mentioned about out-of-country executors do come up, though usually having one in Edmonton defrays some of those issues. So as a general rule, if you're thinking about co-executors, 1 is usually a very good number. I like 1. It's very clean. It's very clear. But if you've got 2 kids and the 2 kids are the beneficiaries and you want to name the 2 kids as executors, well, often now you have built-in accountability and they can skirt a lot of the formal rules and do things informally, and it can be quite smooth. So just do whatever makes sense and ask your lawyer when you're drafting your will, and they'll give you their 2 cents.
As long as those 2 siblings get along.
Oh, you better believe that. If they don't get along, you keep them away from each other.
Exactly. Yeah. What about beneficiaries that pass away before the distribution of their portion of the inheritance? That's
a pretty common thing to happen.
Yeah.
Especially with bigger families, because when mom passes away and she's in her 90s, everyone's in that danger zone, right? It's actually pretty simple. So if someone dies before mom dies, you read mom's will and it usually says what happens if the beneficiary dies before. But if they die after, it's not that complicated. It's just instead of paying the person, you pay their estate, and then their estate will divvy up that money like they do the rest of the property. So that part is easy. Where the complication comes up is that you need to be able to physically hand that check to a person. And when it comes time to get the accounting approved, you can't go to the sibling anymore. You're going to that sibling's executor, who might be a spouse or a child or a friend. So you're dealing with a person you might not know as well. And there may be a delay between the person passing and the executor being formally appointed. So it can cause some friction just from the difficulty in administering that. But most of the time, it's a non-issue. The child has passed away. We just pay them. We write a check payable to the child. It goes into the estate account, just like the CPP benefit or a life insurance payout, and that's the end of it. It's just details you got to watch. That's all.
Yeah, sounds great. Does a beneficiary have to pay tax on their inheritance?
The answer is almost always no. An inheritance is a gift. Gifts aren't taxed. And an estate has paid. So I mentioned that there's a deemed disposition of everything you own when you die. The purpose of that is that all of the tax liabilities we've been carrying in our life, all of them get wiped clean when a person dies. And that means when we're giving money to beneficiaries, the taxes are all paid. Now, the one exception to that is when we have genuine ambiguity about a gift of a specific account that comes with loaded tax obligations, like a RIF or an RSP. And again, the estate is paying the tax on that RIF. And so you just get the asset tax-free. Your what's called an adjusted cost base, the value of it when you received it, and that's your benchmark for calculating gains and losses. You inherit it at its current value when you inherit it. But there are a lot of situations where that's either clearly not intended, or at least a judge says so, and then the beneficiary is expected to pay that tax, usually by way of it being held back from the gift. It's deducted at source, and so you just get less. But as a default rule, no.
That's great. Thank you. Well, there are a number of other questions that we didn't get to because, like I said at the beginning of this Q&A section, they're very specific. And there's probably some confidential information that you would need to know to be able to answer the question. So for those specific questions that were asked, we encourage you to reach out to Ben. His contact information is there on your screen. So if you've got any specific questions that you want to ask, or you would like to talk to Ben about your estate documents, or maybe you are currently an executor and you need some help, Ben would be happy to help steer you in the right direction. Thank you, Ben, very much for all of this. This was a great session. I knew it was going to be a lot of fun when you and I talked about how not to get sued. So that was great. I learned a lot, and I'm sure our listeners did as well. So we'll bring this webinar to an end. A reminder to everyone, this is being recorded, so you can check back on our website. That website again is www.ecfoundation.org. It'll be up by the end of the month. Give us a little bit of time to edit and produce these and get them uploaded to our website. So do check back on our website in a week or two so that you can look at this one and the other 8 sessions that we had this week. There was lots of great information this week. And keep an eye out for our Wills Week, which will happen in October, where we will focus on the importance of having all of your estate documents in order. So again, thanks so much, Ben, and to everyone, have a great warm weekend. It's nice that it's finally sunny here in Edmonton.
And if I could just say one parting word about this topic, I said it at the beginning, but I'll say it again. I don't want anyone to feel like imposing an executorship on a loved one is something you should avoid, or that being an executor is a minefield where you will inevitably get sued and blow yourself up or step in a bear trap. Never mind the fact that there was a bear trap in every slide. Most of the time, these go very smoothly. The reason there are so many rules and so many hoops to jump through is because over a long period of time, literally thousands of years, we've been designing systems to avoid these kinds of problems. And that's why it's so technical and difficult. And there are lots of professionals there to help. And our job is to make sure that we don't run into these problems. We deal with them before they come up. So don't be overly intimidated or fearful of this. Just take it seriously and get the proper help.
That's great. That's a wonderful way to end this session and to end the week. So thank you very much. Thanks again, Ben. Have a great weekend.